Okay, first and foremost, take note that advanced ruling under the Customs Modernization and Tariff Act or the CMTA is under Title 11 or under the provisions regarding administrative and judicial proceedings. Meaning, when you talk about advanced ruling, these are rulings rendered by administrative bodies, whether the Tariff Commission or the Bureau of Customs, and they can be appealed or remedies can be taken from them to the judiciary or to the courts. Please take note that advanced rulings may be on three subject matters. It may be on matters of classification, it can tackle or it can request for advanced ruling on the proper headings of the items involved in the importation. Number two, it may also involve advanced rulings on valuation, whether or not the method for valuation used is proper and whether or not the value arrived at is the proper basis for the duties and taxes computed. And also, number three, advanced rulings may also deal with the matter of origin, whether or not the importation is entitled to or is covered under preferential trade agreements. Now, who may apply for advanced rulings? The provisions of the CMTA are clear regarding this matter. If you look at sections 1100, 1101, and 1102, you can see from there that an importer or exporter may file written applications for advanced rulings. If you also look at CMO 30-2016, you will also see there that aside from the importer or exporter, the CMO allows authorized agents to apply for advanced rulings. Now, with whom should the application for advanced ruling be filed? Take note that we mentioned earlier that advanced ruling may cover three subjects, whether for classification, for valuation, or for rules of origin. Now, for valuation and rules of origin, take note that the application should be filed with the commissioner. This has been clearly stated from sections 1101 and 1102 of the CMTA. This is different from section 1100 dealing with applications for advanced ruling on classification, which should be filed not with the commissioner but with the tariff commission. Next, so when should you file the application for advanced ruling? The very reason why advanced rulings are called as such or why they are called advanced is because the law requires applications for such advanced ruling to be filed 90 days or at least 90 days before the importation or exportation of the product or item. This is pursuant to Section 1103 of the CMTA. So, what is the period within which the advance ruling should be rendered? So, let's take a look at the pertinent provisions of the CMTA under Section 1100. The answer is that the Tariff Commission should render a ruling within 30 days from the receipt of a properly documented application. This is in relation to classification rulings. Whereas for valuation rulings, advanced rulings on valuation, Section 1101 requires that the ruling should be issued within 30 days from submission of the application form and the supporting documents. Now, as regards advanced ruling on the rules of origin, it's also 30 days. The ruling should be also rendered within 30 days from receipt of the application and supporting documents. Now, what happens when the importer or exporter did not file any request for advance ruling and simply proceeded with his or her or its importation or exportation? Now, in that case, if there has been no application for advance ruling on classification, valuation, or origin, and in the event that a dispute arises as regards those matters, for example, there will be a dispute on the valuation or on the proper or applicable heading, then the dispute or the matter shall be resolved as if or applying the provisions of the CMTA on protest, Section 1106. So if there is no advance ruling, if there has been no application for such advance ruling and a dispute later on arises, the pertinent provisions on protest under the CMTA will apply. Now, may an application for advanced ruling cover several items? So the answer is no, because Section 1103 of the CMTA is clear when it says that an application for an advanced ruling shall cover only one product or item. Now, what happens in case of an adverse advance ruling? If you apply for an advance ruling and you received an adverse ruling or an adverse decision, the aggrieved party may, within 30 days from receipt of the adverse advance ruling or decision, may appeal the same to the Court of Tax Appeals. However, if the advance ruling or advance decision is adverse to the government, automatic review or the authority of the Secretary of Finance may come into the picture in cases the decision is adverse to the government. Is there a fee that should be paid when I apply for an advance ruling? Now, yes, CMO 3-20 rather 30-2016 requires the payment of a fee whenever you apply for an advance ruling. It says that the requesting person or the applicant shall accomplish the advanced ruling order payment form in the BOC website and shall pay the same to the Bureau's in-house bank or Land Bank of the Philippines. Then after such payment, Land Bank of the Philippines will issue the official receipt as proof that the payment was made in relation to the application for an advance ruling. Now, what information is generally and specifically required in applications for advance ruling? CMO 30-26 also outlines or enumerates the general and specific requirements for applications for an advance ruling. As to these general requirements, they are as follows. A. The full name and address of the requesting person, including the tax identification number, except if the requesting person is a foreign exporter. B. Name, telephone number, and email address of the contact person who should have full knowledge of the goods at issue and to whom the Bureau of Customs may direct any inquiries or communication. C. A statement as to whether the requesting person is an importer, a producer, and if so, whether the producer directly exports the goods to the Philippines or a foreign exporter, a person exporting goods to the Philippines who is not the producer of the goods. D. If the requesting person is an importer, the name and address of the exporter and or producer should be included. If the requesting person is a foreign exporter, the request should include the name and address of the producer, the importer, if not the same person, and the name and address of the local agent. Now, if the requesting person is a producer, the request shall also include the name and address of the exporter, if not the same person, and that of the importers. Letter E. Whether the request is made by a third-party agent, it should also include the name, address, and contact information of the agent requesting the advance ruling. Now, this should also be accompanied by an authorization letter which need not be notarized, signed by the person for whom the advance ruling is intended, granting the agent authorization to act on behalf of the importer, foreign exporter, or producer. The application should also include letter F, a statement on the basis of the requesting person's knowledge as to whether the goods that are the subject of the request for advance ruling has previously been imported into the Philippines. G. A detailed description of the goods. And H. Whether any information shall be treated as confidential. Now, there are also specific requirements for applications for an advance ruling. For example, if you apply for an advance ruling regarding origin, there are specific requirements under Section 3.2.1 of CMO 30-2016, and they are as follows. A. The country of origin and vision for the goods. B. The applicable basis for claiming origin, stating that the request for advance ruling is to claim preferential tariff treatment. C. Samples as necessary, photographs, plans, catalogs, copies of technical literature, brochures, laboratory analysis results, or other documents available on the composition of the goods and their component materials, which may assist in describing the manufacturing process or the processing undergone by the materials, or any other documents that may assist in determining the origin of the goods. D. The conditions enabling origin to be determined, the materials used and their origin, tariff classification, corresponding values, and a description of the circumstances enabling the conditions in question to be met. And E. Whether the goods in question are the subject of an origin verification process or any instance of appeal or review before any governmental agency, appellate tribunal, or court. Now, in case the advance ruling application is for valuation, there are also specific requirements therefore. They can be found in Section 3.2.2 of CMO 30-2016. And these specific requirements are as follows. A. The valuation method and vision for the goods. B. The legal basis for the claimed valuation method. C. Description of the nature of the transaction. D. Any relationship between the parties. E. Specific information depending on the valuation issue in question. And letter F. Other relevant documents. May an application for advance ruling be withdrawn? CMO 30-2016 is clear in this regard. It allows a requesting person to withdraw the request, but such withdrawal should be made before the Bureau of Customs decides on the application. In that event, the application shall be terminated as of the date of the receipt of the written withdrawal. Now, what is the effect of such withdrawal? Such withdrawal shall not prohibit the filing of another request on the same subject. May issuance of an advance ruling be declined, and what is the remedy if issuance of advance ruling is declined? Yes, the issuance of an advance ruling may be declined for the grounds enumerated under CMO 30-2016, and these grounds are as follows. A. The issue involves a matter that is pending before the courts or is the subject of an administrative review or under post-clearance audit. B. A request for advance ruling on the same goods is already filed by the same requesting party. However, an earlier request filed by an agent shall be declined if a latter request is filed by the principal. C. An adverse ruling on the same goods has been issued to the same requesting person. And D. The request is based on hypothetical situation. Now, in the event the issuance of an advance ruling is declined, the Bureau of Customs shall promptly notify the requesting person in writing through electronic means, clearly stating the reasons why advance ruling has been declined. Now, what is the remedy if the issuance of an advance ruling is declined? Now, the remedy is provided for under CMO 32 2021. which says that um, in case the issuance of an advance ruling is declined, a motion for reconsideration may be filed. Now, what act or acts are penalized in relation to applying for an advance ruling? They are enumerated under CMO 30-2016, and they are as follows. A. Intentional misrepresentation of any material fact regarding an application for advance ruling. It shall be penalized by the rejection of the request and the revocation of an advance ruling if it has been issued. Letter B. Submission to the Bureau of counterfeit or otherwise false or inaccurate documents in support of a request for advance ruling. It shall be penalized by the rejection of the application and the revocation of an advance ruling if one has already been issued. Next, what is the duration of the validity of an advanced ruling? An advance ruling is valid for 3 calendar years from the date of its issuance, provided that there is no change in material facts and circumstances after the issuance of the ruling, and there is no change in the applicable law.